Article 3 Treason Clause Common Interpretation by Paul T. Crane and Deborah Pearlstein. Treason is a unique offense in our constitutional order, the only crime expressly defined by the Constitution and applying only to Americans who have betrayed the allegiance they are presumed to own the United States, while the Constitution's framers shared centuries-old view that all citizens own the duty of loyalty to their home nation. They include the Treason Clause not so much to underscore the seriousness of such a betrayal, but to guard against the historic use of treason persecutions by repressive governments to silence otherwise legitimate political opposition. Debate surrounding the clause and the Constitutional Convention is focused on ways to narrowly define the offense and to protect against the false or flimsy persecutions. The Constitution specifically identifies what constitutes treason against the United States and, importantly, limits the offense of treason to only two types of conduct. One, levying war against the United States, or two, adhering to the enemies of the United States, giving them aid and comfort. Although there have not been any treason persecutions in American history, indeed, only one person has been indicted for treason since 1954. The Supreme Court has had occasion to further define what each type of treason entails. The offense of levying war against the United States was interpreted narrowly in Ex parte Bowman and Swarthout, 1807, a case stemming from the infamous alleged plot led by former Vice President Aaron Burr to overthrow the American government in New Orleans. The Supreme Court dismissed charges of treason that had been brought against two of Burr's associates, Bowman and Swarthout, on the grounds that their alleged conduct did not constitute levying war against the United States within the meaning of the Treason Clause. It was not enough to Justice John Marshall's opinion emphasized merely to conspire to subvert by force the government of our country by recruiting troops, procuring maps, and drawing up plans. Conspiring to levy war was distinct from actually levying war. Rather, a person would be convicted for treason for levying war only if there was an actual assemblage of men for the purpose of executing a treasonable design. In so holding, the court sharply confined the scope of the offense treason by levying war against the United States. The court construed that the other treason offense authorized by the Constitution similarly narrowly in Kramer v. United States, 1945. That case involved another infamous incident in American history, the Nazi saboteur affair. Kramer was prosecuted for treason for allegedly helping German soldiers who had surreptitiously infiltrated American soil during World War II. In reviewing Kramer's treason conviction, the court explained that a person could be convicted of treason only if he or she adhered to enemy and gave that enemy aid and comfort. And the court explained the citizen intellectually or emotionally may fear the enemy and harbor sympathies or convictions disloyal to this country's policy or interest, but so long as he commits no act of aid and comfort to the enemy, there is no treason. On the other hand, a citizen may take actions which do aid or comfort the enemy, making a speech critical of the government or opposing its measures, profiteering, striking defense plans or essential work, and hundreds other things which impair our cohesion and dismiss our strength. But if there is no adherence to the enemy in this, if there is no intent to betray, there is no treason. In other words, Constitution requires both concrete action and intent to betray the nation before a citizen can be convicted of treason. Expressing traitorous thoughts or intentions alone does not suffice. To further guard against the prospect that the government could use force or passion-driven accusations of treason to undermine political opponents, the treason clause provides that the offense may only be proven by open confession in court or on the testimony of two witnesses of the same overt act. The overt act requirement was designed both to limit the kind of substantive behavior treason could punish only conduct, not mere expression, and to ensure that the conduct itself demonstrated the defendant's intention to betray the United States. Believing that no witness could meaningfully testify to a defendant's internal state of mind, the Supreme Court made it clear that the defendant's disloyal intent must be evident from the witness acts themselves. The government would have to prove that each overt act alleged actually gave aid and comfort to the enemy. The two witness requirement was likewise geared to raising the bar to persecution, applying this to all acts of the defendant which are used to draw incriminating inferences that aid and comfort have been given. While there was no dispute in Kramer's case that he had met with a man who turned out to be a German soldier in the United States, the court concluded that these facts alone failed to establish Kramer had actually given that enemy soldier aid and comfort. The court accordingly reversed Kramer's treason conviction. The Constitution also narrowed the scope of punishment for treason as compared to English common law. The final clause of this section established that while Congress has the general power to establish penalties for committing treason, Congress may not work corruption of blood or forfeiture except during the life of the person convicted for treason. Corruption of blood is a reference to English common law, which prohibited family members from, among other things, receiving or inheriting property from a person convicted for treason. Under the Constitution, that punishment may not extend beyond the life of the person convicted of treason. Matter debate. The first perspective, does the treason clause still matter? Yes, by Paul T. Crane. Treason persecutions have essentially disappeared. Although treason was never a popular charge for federal prosecutors, treason persecutions attended nearly every armed conflict in American history up to and including the Second World War. Since 1954, however, only one person has been charged with treason against the United States, and that single instance was relatively unusual. In 2006, a federal grand jury indicted Adam Gandhian for treason based on his participation in several Arquad propaganda videos. Gandhian was not in custody at the time of his indictment and was later killed in the 2015 drone strike in Pakistan before he could stand trial in the United States. The traditional explanation for why treason charges have vanished is that the Supreme Court in Kramer v. United States 1945 made treason so difficult to prove it was no longer a realistic option for federal prosecutors. But then conventional wisdom is wrong. The court in Kramer did make treason more difficult to prove. It otherwise could have, but did not raise the bar so high that treason charges were no longer plausible. Indeed, the federal government pursued nearly a dozen treason prosecutions after the court decided Kramer, and secured convictions in nearly all of those cases. As for 1954, there was little reason to believe that treason charges would fall into complete disuse. A better explanation for the disappearance treason persecutions comes from another aspect of the Kramer decision. The government in Kramer argued that the treason clause should be interpreted leniently so that treason charges could be readily deployed during times of war. The court dismissed the government's concern, observing that the treason offense is not only nor can it well serve as the principal legal weapon to vindicate our national cohesion and security. The court further emphasized that the power of Congress is in no way limited to enact prohibitions of specified acts thought detrimental to our wartime safety. Critically, the court indicted that federal prosecutors could pursue non-treason charges, offenses such as violating the Espionage Act or the Treating with the Enemy Act, without needing to satisfy the procedural requirements of the treason clause. This understanding was confirmed a few years later during the persecution of Julius and Ethel Rensenberger for disclosing automatic secrets to the Soviet Union. The Rensenbergers were charged with conspiracy to commit espionage, not treason. But the prosecutors and even the trial judge often conflated the charges, referring to the Rensenbergers and traitors and having committed treason. Rensenberger claimed that their convictions had violated the treason clause because they were effectively convicted of treason, but without the attendant constitutional safeguards. The United States Court of Appeals for the Second Circuit rejected Rensenberger's argument in 1952, and the Supreme Court declined to intervene the following year. By 1954, therefore, Rensenberger and Kramer had firmly established that the prosecutors could bring non-treason charges without the procedural safeguards provided by the treason clause, even if the conduct in issue could plausibly be considered treasonous. At the same time, Congress passed several new national security laws, including the Internal Security Act of 1950 and the Communist Control Act of 1954. And the many of federal crimes expanded, prosecutors had less and less reason to resort to treason charges. Why bother with the two-witness rule or the word act requirement when a variety of alternatives and substitute offenses exist? Because treason persecutions have effectively disappeared, one might wonder about the continued relevance of the treason clause. But the clause should not be relegated to the dustbin of history for at least two reasons. First and foremost, and the indictment against Adam Gaden demonstrated treason is not yet completely extinct. And because the court in Kramer did not in fact make treason impossible to prove, there remains the possibility that treason charges could one day increase in relative frequency. If that does happen, the treason clause sets forth important requirements on how such charges must be proven. Second, while the specific persecutions set forth in the treason clause may be limited to treason persecutions, the principle underlying the clause are not. Indeed, they should serve as important reminders about national security cases more generally. The framers correctly believed there was a crucial distinction between tutorial's actions and treasoner's thought. Departing from English common law, which at the time recognized constructive treason, the Constitution requires some sort of action before a person could be convicted for treason. The line between conduct and conscience dovetails with First Amendment values. It is one that should be respected beyond the narrow confines of treason. In addition, the framers recognized that the national security offenses are more likely to inflame public passions and therefore deserve heightened procedural protections. This insight also extends beyond treason cases and is one Congress, federal courts, and the public would do well to remember. Next perspective, Treason by Any Other Name by Deborah Pearlstein. The Constitution uses the word war in only two places. In Article 1, most famously, a law allocating to Congress the power to declare war. And again here in Article 3, giving the courts the power to hear cases requiring them to determine whether an individual is guilty of levying war against the United States. The treason clause in this sense among the stronger pieces of textual evidence that the courts were to have as much a role in evaluating the existence of certain individual threats to national security, and they would in adjudicating any other kind of crime. Indeed, particularly since the attacks of September 11th, the federal courts have faced dozens upon dozens of cases involving accusations that individuals have aided our enemies. Individuals charged not with treason but with providing material support to a terrorist or a terrorist group. Yet while the treason clause includes special rules of evidence to help guard against the danger that otherwise peaceful opponents of our government would face false accusations of supporting our enemies, neither the material support statute nor other comparable federal offenses contain any such safeguards. Is it really consistent with the treason clause for there to be such a ready way to avoid its protections? For government to be able to achieve the same ends, persecutions for aiding the enemy, without having to encounter any of the hurdles designed to guard against abuses of such a charge that so concerned the framers? While the Supreme Court recognizing Congress' broad power to criminalize a wide range of offenses harmful to the United States, the court was also careful to underscore the reality that even this power had its limits. Of course, we do not intimate that the Congress could dispense with the two-witness rule merely by giving the same offense another name, as when appeal court facing a terrorism persecution arising after the First World War, after the First World Trade Center bombing thus acknowledged. The question whether a defendant who engaged in subversive conduct might be tried for a crime involving all the elements of treason, but under a different name, and without the constitutional protection of the treason clause, remains open. Lower courts have, for the most part, been able to avoid answering the question directly, but the concluding that other crimes, however similar, do not contain any of the same elements required to prove treason itself. Unlike treason, the crime of material support, for example, carries no requirement that defendants have breached allegiance owed to the United States. Citizens and non-citizens alike can be charged with the offense. At the same time, there is at least some reason to worry that the material support persecutions of Americans and American organizations could involve forms of expressive activity, translating enemy statements into English, or producing training material on international law that an enemy organization could use to peacefully resolve disputes that the framer would have expected to be persecuted, if at all, only under heightened procedural protection. While the label traitor may still today be a uniquely powerful public condemnation, those convicted for providing material support to any one of the 5 dozen organizations the United States currently lists as foreign terrorists bear substantial penalties of their own. The Treason Clause, much like the Constitution's first 10 amendments, is principally designed to protect core individual rights, most especially freedoms of expression and dissent. As Justice Jackson explained for the criminal court, the basic law of treason in this country was framed by men who, as we have seen, were taught by experience and by history to fear abuse of the treason charge against as much as they feared treason itself, almost as much as they feared treason itself. This manifest purpose, coupled with the clause's placement among the powers of Article 3 courts, suggests that a technical element-by-element test to determine whether a new crime is in all circumstances exactly the same as the crime of treason may be an overly formal approach to determining whether national security persecution deserves the special evidentiary protections the Treason Clause requires. Where a persecution amounting to a charge that American has aided the enemy of the United States implicates such basic freedoms, the Treason Clause may provide additional constitutional basis for arguing that the courts must take special care in protecting against prosecutorial abuse.